We're looking at the justice system's own website, justice.gc.ca. Provisions of the Charter. This Charter applies to the Parliament and Government of Canada, and this Charter applies to the legislature and government of each province, in respect of all matters within the authority of the legislator of each province. Alright, so the Charter applies to the government, and the Charter applies to the legislators, those who are making up the statutory law. Municipalities. The court has said the Charter applies to municipalities and their actions. Notice that. Their actions or interactions. Private corporations. Private corporations are entirely creatures of statute. They have no power or authority that does not derive from the legislation that created them. The Charter does not apply to them, however, because legislators have not entrusted them to implement specific governmental policies. While the legislation creating corporations is subject to the Charter, corporations themselves are not part of the government for the purpose of Section 32 of the Charter. Alright, so I just read that straightforward, just from top to bottom. And how many caught what's being said here? How many understand what's being said here? So here we have the justice system writing that private corporations are entirely creatures of statute. Well, we understand that, right? If you watched my other video, I walked you through how corporations are set up in law, how the Corporations Act is required and is used in order to create a corporate body here in Canada. Now it goes on to say they have no power or authority that does not derive from the legislation that created them. Agree. The Charter does not apply to them, however. Well, why? So they're going to tell us that the Charter doesn't apply to these corporate bodies. But why? Because legislators have not entrusted them to implement specific governmental policies. So that's the reason why. So they're giving us the legal reason why the Charter doesn't apply to private corporations, and they say because the legislator has not entrusted them or given them the power to implement specific governmental policies. It doesn't say that these private corporations are not part of the government. It doesn't say that these corporations are not controlled by the government, right? It just says that the legislators didn't entrust them to implement the obligations of the Charter. While legislation creating corporation is subject to the Charter, okay, that's a very powerful statement, right? So they're saying the enactment, they're saying the statutory power that created your corporation, that statutory power is subject to the Charter. And if we can find limitations and abridgments in that legislation, if we can find where that legislation is limiting and abridging our natural rights when we go to open up a corporate body, well then we can exercise our Charter rights. And it goes on to say corporations themselves are not part of the government, period. It's not what it says, right? It says they are not part of the government for the purpose of Section 32 of the Charter. Because we know that they are part of the government, right? Because when we look into corporations enactment, we see very clearly that the minister and the director remain in control of that private corporation. And the minister and the director can order your corporation to perform certain acts and certain duties and certain responsibilities. And if you fail to comply, well, they can close your corporation because they are in control of your corporation. Now here when it says that corporations themselves are not part of the government, it doesn't say period. It says it's going to qualify it. They're not part of the government for the purpose of Section 32 of the Charter. They haven't been entrusted to implement the Charter. But nevertheless, they are still controlled by the Crown. A private corporation is still controlled by the Crown. So let's look into the Federal Court Act, Article 17.1. It reads, except as otherwise provided in this act or any other act of Parliament, the Federal Court has concurred original jurisdiction in all cases in which relief is claimed against the Crown. So if you're looking for relief against the Crown, and the Crown means Her Majesty, that's what it means. It doesn't mean the government. When the law says Crown, it's referring to now the King, King Charles. without respecting the generality of subsection 1, the federal court has concurred original jurisdiction except as otherwise provided in all cases in which, now look at letter D, the claim is for damages under the Crown Liability and Proceedings Act. If my claim for damages against the Crown comes through the Crown Liability and Proceedings Act, then the Federal Court of Canada has the obligation to hear my claim. Federal Court Act, Article 17.5. The Federal Court has concurred original jurisdiction, letter B, in proceedings in which relief is sought against any person for anything done or omitted to be done in the performance of the duties of that person as an officer, servant, or agent of the Crown. So the federal court has the ability to hear your proceeding if you're seeking for relief against an officer, a servant, or an agent of the Crown if they omitted to do or perform their duty. If they fail to perform their duty and the obligation that they have, then there's a claim against them. And remember, the municipalities and the actions that the agents of the municipalities take with you are subject to the charter. By default, they are considered officers and servants of the Crown or agents of the Crown. Just like when we look into the CRA, Canadian Revenue Agency enactment, right? In Article 4.2, it says agent of, now it should be His Majesty. The agency is for all purposes an agent of Her Majesty in right of Canada. So the CRA, right, would fall under the definition in the Federal Court Act. Remember, the Federal Court Act says, in proceedings in which relief is sought against any person for anything done or admitted to be done in the performance of the duties of that person as an officer, servant, or agent of the Crown. So the ones who work in the government positions, right, and send you the letters and contact you, well, they're agents and officers of the Crown. And they have to follow the obligations of the Charter and the fundamental rights that are expressed in the Charter. And if they omit to do that, when you confront them, if they omit to follow their obligation, and it's not their obligation, it's not that person's obligation directly, the one who's just hired and is working in that office to make a paycheck for himself or herself so they can provide for the family. It's not their fault. It's not their responsibility. It's the Crown's responsibility. It's Her Majesty's responsibility. But if that officer, if that individual who's operating in that capacity, right, fails, omits what? To perform their duties towards you, then they become liable. Looking at the Crown Liabilities and Proceedings Act, interpretation section, definition of the Crown means His Majesty in right of Canada. So it means His Majesty. That's what it means. I don't have a problem with the Crown as it's concerned civil rights and civil laws and civil obligations. It's not my problem. I'm not coming to court claiming that, oh, the Crown is doing something to me in the civil capacity that I don't like. I've got a problem with the Crown that they're not allowing me to exercise my fundamental natural human rights and freedoms. That His Majesty signed the accord, signed the covenant, and brought into existence in Canada, which their agents are refusing to allow me to operate. That's the problem that I have with the Crown. The problem that I have with the Crown is that you're failing to allow me to exercise my natural rights, but you're trying to force me to operate civil rights and civil obligations instead. Even though it may be civil obligations that I'm wrestling with, what I'm ultimately bringing before the court, right, is the fact that my fundamental human right, my natural right, is being limited and abridged contrary to their obligation, contrary to what they're supposed to be doing. Whether it be a municipality, right, sending me letters or account statements requiring that I have to pay an account statement for taxation of the property on their territory, or whether it be the CRA sending me notice of assessments, making a requirement to pay based upon that assessment. My problem is what? My problem is that those actions that you are taking with me, right, they go against my charter rights. They'll go against my natural rights, my fundamental rights. There's operations of law that you are using wherein you are trying to limit and abridge my natural right. So with the municipality, right, they take absolute title away from you and they return to you a qualified title. I explained to you in my video how they're doing it. I showed you in their statutory power how they're doing it, that they're operating as an agent on your behalf without you knowing, and they're taking the absolute title and returning to you a qualified title. Well, why can they do that? Well, you're an officer of their corporate body, right? And they're the executive powers. And they have the right to do things in law that you are unaware of. The executive, right, when they make decisions in their corporate body, they don't go down and tell the cooks. They don't go down and tell the cashiers what they're doing. No, they do it. And that's the same thing that you're seeing. Anytime you have any communication from a government agent or from a municipal body, a municipal agent, the proper response is to elevate that to the one who's in control of that executive body. So if it would be the CRA, then it would be the minister of the CRA. If it would be the municipality, then it would be the mayor of the municipality. You don't care how they respond. You don't care what they really say back. You do in a way because you're looking for them to allow you to operate your fundamental rights and freedoms. But if you have a mayor, if the trouble is a municipality and you have a mayor, right, that mayor has no idea about fundamental rights and freedoms. You could go and have a coffee with her and tell her, hey, let me read you the Charter, Article 7. Everyone has the right to life, liberty, and security of the person. What does that mean? And they'll be like, well, I don't understand. What are you talking about? What do you mean? They themselves have no idea of fundamental rights, human rights, and your natural rights being in operation in law. But that's not what you're worried about. You're worried about setting a pathway or showing a pathway of your communication. And so you elevate it to the executive of the body that's contacting you. And you lay into that executive and you tell them, listen, you're limiting and abridging my fundamental right. Well, how? Well, you got to know how. If you're going to communicate with them, you got to know how. You got to be able to point to the statutory power and say, you see, when the legislator created this operation of law, it limited and abridged my right. And now you're using that operation of law against me, and you're limiting and abridging my right. And remember, the courts have already said, the municipality are not to take actions, not just laws, but actions limiting and abridging your right. And of course, they're going to hide behind the statutory power. And they're going to say, oh, well, we're just obeying the statutory power. We're just obeying the law or the bylaw. Well, that's not okay. Why? Because that bylaw and that law is limiting and abridging my right. But you see, that's your responsibility to bring that before the court. You have to show the court that that legislator and that law has placed an abridgment and a limitation upon your natural right. So again, my problem is that you're limiting and abridging my natural right. So I'm walking through the federal court, right? And we're walking through the Crown Liability and Proceedings enactment. So now law has to open up the door. Law has to produce an operation for me that allows me to come before them and express what I'm going through and express what the government is doing to me. My position is that it's a limitation and abridgment of my natural rights. So again, the court has to open up the door to allow me to bring that argument before the court. Now look here in Article 2.1. For the purpose of Section 3 to 5, person means a natural person of full age and capacity other than His Majesty in right of Canada or a province. So here we see that the enactment, right, is opening up the door because it's describing a person as being a natural person. Now, I'll contend to you that a natural person does not mean a man or a woman or a human being. But what a natural person allows you to do in law is to charge that you would say, I don't like to use this expression, but that statutory creature, you would charge that natural person with the right that you as a man are able to exercise. So the right that you are able to exercise as a man or woman as your natural right, as your fundamental right, that can be brought into, that can be charged into, that can be put upon the natural person before law. So that natural person then becomes before the court your means to expressing your right and your means to having your right defended. So that's why here in law it says that person means a natural person. Why? Because law has to allow you to charge the natural person with your fundamental right. Law has to make a way for you to be able to bring that natural right before the court. And if it was just a statutory creature here, well, you couldn't do it, right? Because a statutory creature is controlled by enactments, it's created by enactments, and it can't be charged with a natural right. But here, this natural person can be. So the court is opening up the door for you to come before them with your problem. And we know that our problem is what? Well, you're limiting and abridging our natural right. And the natural person is going to be charged with that natural right. It's going to represent the natural right for me before the court. Here's the Municipal Act of Ontario, and they're all the same. But here in Article 9 it says, a municipality has the capacity, rights, powers, and privileges of a natural person for the purpose of exercising its authority under this or any other act. All right, well, we know that a municipality, right, is a body corporate. We know that 100% in law. But here it says that that body corporate has the rights, powers, and privileges of a natural person. So you see, a natural person in law is not a human being. It's not a man or woman. But a natural person in law can be charged with capacity, rights, powers, and privileges. So that's why when we look in the Crown Liability and Proceedings Enactment, the person that's coming before the court is considered a natural person. Why? So that natural person can express the natural right. So that natural person can express their fundamental right before the court. So you're standing before the court under the Crown Liabilities and Proceedings Enactment as a natural person, and you're claiming that your fundamental rights have been limited and abridged. And look what it says here in Article 3. The Crown is liable for damages for which, if it were a person, it would be liable. In Quebec, the damage was caused by the fault of a servant of the Crown, or in any other province, a tort committed by a servant of the Crown. And a tort is a wrongful act or an infringement of a right. So the law is very clear when it uses the expression here. It says a tort on purpose. Why? Because a tort is an infringement of the right. And that's what you're complaining about. You're saying I have a natural right, but it's being infringed upon. And here the law is opening up the door for you to come in as that natural person, to charge the natural person with the right that you're claiming is being limited and abridged, and to claim that it's a tort against you. Subsection 2. A breach of duty attaching to the ownership, occupation, possession, or control of property. Well, there you go again, right? That's a problem concerning what? The municipality and their actions by taking away your absolute title and returning to you only a qualified title. So the tort is committed by a servant of the Crown. The infringement of your natural right is committed by the servant of the Crown. When the officer or an agent of the CRA does what they do, well, they've committed a tort, whether they understand it or not. The Minister of Revenue, if he denies you when you contact him, well, he's committed a tort. He's infringing upon your right. The municipality, same thing. If they refuse to return to you absolute title of your property, well, they're in breach of duty, attaching to the ownership and control of that property. And you can go before the federal court and you can claim that the Crown is liable for damages. And you can seek for a judgment against the Crown. A judgment for damages, but also a judgment to allow you to exercise your fundamental right, to stop the party from infringing upon your right. Crown Liabilities and Proceedings Enactment, Article 21.1. In all cases, so all cases, right? Every case, where a claim is made against the Crown. And the Crown is who? His Majesty. Or His Majesty's agents, servants, except where the federal court has exclusive jurisdiction. So look at that terminology, exclusive jurisdiction. With respect to it, the superior court of a province in which the claim arises has concurrent jurisdiction with respect to the subject matter of the claim. So here it's saying that you can go to the superior court of your province under the Crown Liabilities and Proceedings Enactment, and you can lay your claim in the superior court, but only if the federal court does not claim exclusive jurisdiction. If it doesn't say you can only come to federal court. When you look back into the federal court enactment, Article 17, it says, except as otherwise provided in this act or any other act of parliament, the federal court has concurrent original jurisdiction in all cases in which relief is claimed against the crown. It doesn't say exclusive. So the federal court is not exclusive. You don't have to go to the federal court, but the federal court can hear you. If your case is under the Crown Liability and Proceedings Enactment, then the federal court can hear you, or the provincial court of your province can hear you also. All right, so we're seeing a measure. We're seeing a measure in operation, right, that's giving effect for us to enforce our natural rights, our fundamental rights. The Crown Liabilities and Proceedings Enactment, right, it sets up the person to be the natural person. Thereby that natural person can be charged with a natural right or a fundamental right. And you can go to the federal court or you can go to the provincial court under the Crown Liability and Proceedings Act, and when you approach the court, whether it be the federal court or the provincial court, you're approaching them and you're looking for their original jurisdiction, and you're approaching them with your fundamental right. Remember that the judges are under the presumption that all the laws, all the statutory laws, they conform to your charter rights. And by default, they conform to the international covenants. So they're saying that all these legislative laws, all these statutory powers, they respect natural fundamental rights, even though they don't. And it's your responsibility when you go before the court, when you go before the judge, to wake them up, so to speak, to show them that the operation of law in the legislative statutory power is limiting and abridging your natural right. And when you can do that, then you force the court to produce a remedy for you. So you can go to Eternally Aware and you can get the information package that's there on that website, and it will walk you through this in a deeper detail. Or you can continue to scratch your head and wonder what to do. The courts will hear you. They have to hear you. They don't want to hear you. So much so that they're going to try to keep you out of court. Try and keep your documents from getting into court because they don't want to face the situation. But knock on their door.